growing up, we were told April 1st was April Fool's Day, but it ended at 12 noon in Kenya. I don't know about your countries. In Kenya, it ended at noon. So this is not April Fool's Day, although I feel like Gift just fooled us because he made us prepare for an hour, and now he's made it 30 minutes. I'll request my panelists to introduce themselves very briefly, half the introduction they were planning because it's half the time. Cairo.
My name is Cairo Thua from Viva Africa Consulting. Half the time, so we are a specialized tax, legal, and financial advisory firm, well known to have been one of the first people on the REITs and other products. Thank you.
My name is Christabel Shala. I'm from Zim. I am Group Legal Manager for Terrace Africa Group of Properties. We've got presence in 4 countries, Zimbabwe, where we are headquartered, Zambia, Mozambique, and South Africa. So we are predominantly a property management, property development, and asset management firm. We are responsible for anchoring and managing the first REIT in Zimbabwe, which is the Tigere Property Fund. I also come to you as Secretary of the REITs Association of Zimbabwe and incoming chairperson.
So my name is Kimani Njane. I'm a partner at the firm of Mboya Wangongo and Wayaki Advocates. I practice primarily in corporate commercial law, but I also split my time between commercial dispute resolution. For lawyers who are here, when we're applying for a license with LSK, we have to categorize the various practice, and that constitutes about 15% of my practice. But I also head the governance practice of the firm. Now, Mboya Wangongo and Wayaki Advocates, which is a gold sponsor, I must say, for this conference. I don't hear a lot of applause. is a corporate commercial law firm, midwifed, and I know Ruth said that she's the mother of REITs in Kenya. I think we are the midwives of REITs in Kenya, having midwifed the very first REIT in Kenya, Ilam Fahari REIT. We are also a capital markets law firm, listed quite a number of entities in the Nairobi Securities Exchange, listed a number of entities also in the Rwanda Stock Exchange, and we're also largely involved in the development of the capital markets right now in Ethiopia, which is currently at its nascent stage. So REIT is a very passionate practice group in our firm.
Okay. Thank you. He was only given that leeway because he's a good sponsor. Full disclosure, I am a partner in Mboya Wangongo and Wayaki Advocates. I will not reintroduce it because it's been introduced by Kimani. So in this session, we will be examining the policy and regulatory frameworks shaping REIT markets, especially in Kenya, with a focus on structural and legal changes, tax reforms, incentives, and the possible harmonization of regulations across jurisdictions. We've talked about Uganda, Ghana, Zimbabwe. The session, we will also explore how aligned frameworks can support market growth and unlock possible cross-border investment. We'll seek to also draw lessons from more developed markets, such as the US, Europe, Asia, if we have time, and we'll highlight global best practices and their relevance to our markets. In this session, we also try and compare different REIT structures. I think constantly, those of you who've heard me talk about REITs, I'm often telling promoters that it is not their REIT, and I think that completely scares people. So you're going to be looking at, is there a structure? Is it possible to get people to have more skin in the game, more certainty about post-promotion life of a REIT? Because as it is right now in Kenya, really, the promoter who becomes a manager can easily be removed from being the manager, and that completely scares promoters. So you'll be looking at that. What is there another way of structuring REITs? And to kick off, I will ask Kimani very briefly, and one of the things, I'm aware that there are some people here who are here for the first time. Maybe they're hearing a lot of jargon, so I want to ask our panelists to keep it toned down, the jargon out. So Kimani, tell us, because we're hearing a lot about REIT structures, remind us how REITs are structured in Kenya and what other structures could possibly be considered for purposes of REITs, very briefly.
Yeah, thank you, Peter. As a lawyer, that's a very difficult request, so I'll try to keep the jargon down. But REITs in Kenya, generally, unlike in many jurisdictions, and probably also contrasted with other collective investment schemes, for which a REIT is, and we'll be getting into the details of that, is that it's a single structure regime. Kenya is a strict single structure regime. REITs are established as what we call unincorporated common law trusts, under Cap 167 as the primary law, and then the REITs regulations of 2013. And what that means is that as an unincorporated common law trust, a REIT is a trust. And a trust is a relationship managed by a trustee, and for the beneficiaries, their share or their ownership in such a relationship, such a trust, is a unit trust. Now, REIT, again contrasted with many jurisdictions in Kenya, has a trustee. Again, as we said, a trustee sits at a very fiduciary position, because again, a REIT, again unincorporated, is not a corporate body. A corporate body does not have perpetual succession, cannot hold an asset in its name, cannot even be sued in its name. Even when suing a REIT, you'd have to sue the trustee. And for that reason, the assets of the REIT are held by the trustee, who holds and sits at a very fiduciary position. The second level of REIT structure is the management of it. REITs are managed by a REIT manager, who then acts under the direction of the trustee itself, the management agreement, and the REITs regulation. The other critical player within the REIT ecosystem is a custodian, who sometimes we wonder whether is relevant, and those are some of the discussions, the contemporary discussions around regulatory reforms that we'll be speaking, because most of the trustees are a bank and the custodian is a bank, and the question is, because the trustee is supposed to hold the assets of the REIT, including the cash asset of the REIT, then again we have that second layer of the REIT. Another thing that we need to note on Kenya and the REITs market, I know we've had examples from South Africa, from the US, from the REIT, from the NAREIT chair, in terms of how they're structured. But one of the distinguishing elements in Kenya REITs is the issue of eligible real estate. REITs in Kenya must invest in eligible real estate. And of course, we'll be having conversations around what is eligible real estate. There's also a bifurcation of the REIT structure. I'm just checking with Peter so that I'm keeping
You just that last one? I take it you want to tell us about IREITs and DREITs?
Exactly.
There's a distinction, yes.
As also a critical distinguishing element in Kenya is that we have that bifurcation between a DREIT, which is a REIT that invests in construction and development of real estate, and IREIT, which then invests in the investment of income generating,
correct,
generating assets. So in a nutshell, that is our REIT structure. But looking at other jurisdictions, and Peter has asked me to speak briefly about...
Maybe let me keep that, let me spare that for a later question so that we hear the others. I'm very conscious of the time. We'll come to that. Cairo, on your part, would you highlight for us what tax incentives are currently available for REITs in Kenya, and perhaps the ease or otherwise of accessing them?
Thank you, Peter. I think that's one of the simplest questions that anybody could ask. So I'm going to answer. Technically speaking, there are two fundamental tax advantages for a REIT. One is the income tax status, and the other one is the taxes involved in getting the properties out of the REIT. Mm-hmm. Now, with those two, we say we're in a relatively good place. Courtesy of Jeff Odundo, Paul Kavoma, NSC people. There's been a lot of lobbying for the other tax incentives that should be there. And I think in the last probably 1 month, it got to the highest level, and the highest level of the land said, stop all these discussions, give all those incentives to the REIT. And we believe that that is coming. And our RAK has already sent a submission. If I was to say, let's trust the government, I would say the tax discussion is over. You're getting all the exemptions. Thank you. One of the other...
But that's a promise. That's not yet available.
Well, it's not my place to talk politics.
Okay.
It's already gone to Treasury and Parliament.
Okay.
So it should come.
Yes,
or
yes.
effectively the message was, we have understood.
Yes.
We know what the REIT needs.
Yes.
Let's stop all this debating and talking. Let's go ahead and do it.
Okay, great.
And that was nice. One of the interesting, good advantages we have in Kenya, and this is a continuation from what you've said, is that, yes, the REIT is an unincorporated trust, which is okay. And all the lawyers and everybody will say, this can create a problem as to who the legal owner is and what the asset is. Fortunately, from a tax perspective, the Kenyan REIT is allowed to actually hold investee companies, which are also tax exempt. Now that basically provides you with a corporate shield cover, and the REIT asset becomes the shares, not the actual underlying real estate. That really makes everything much more easier and safer for everybody. Thank you.
Thank you very much. Cairo has delivered a promise on behalf of somebody. We look forward to that in a few months' time. I'm sure there are promoters who are waiting to see that come to pass. Christabel, you have four REITs currently on the ZSE. What structures do REITs take, and what tax incentives are available to REITs in Zimbabwe?
Okay, so in Zimbabwe, yes, I confirm we do have 4 listed REITs. 2 are listed on the Zimbabwe Stock Exchange, the ZSE, which is local currency denominated, the local currency being the Zimbabwe gold dollar. And the other 2 are listed on the VFX, which is the Victoria Falls Stock Exchange, which is denominated solely in United States dollars. So REIT structures in Zimbabwe are trusts which, opposite to the Kenyan framework, are incorporated trusts. So in Zimbabwe, trusts hold separate legal persona. They're capable of holding title in their own name. So the trustee in a Zimbabwe REIT setting only acts as the custodian of physical documentation where title is concerned concerning the REIT. And the trustee predominantly takes on the role of protecting investor interests and ensuring that there are transparent governance policies that are in place for a REIT at any given time. So similar to Kenya, trustees are predominantly financial institutions, your banks, which are registered as such by the Securities and Exchange Commission of Zimbabwe. So key takeaway, incorporated trusts. From a tax treatment perspective, REITs in Zimbabwe do benefit from exemption from income tax, and investors are levied with a withholding tax at investor level. Currently, our legislation is silent on capital gains on disposal of REIT property, which is something that is also currently being debated in Parliament and in consultation with the Ministry of Finance. REITs in Zimbabwe are not exempt from stamp duty, and they're also not exempt from VAT on acquisitions, which significantly hampers certain transactions. However, VAT is recoverable over a period of 6 to 9 months. But this has been choking a lot of transactions at inception. So as a REITs Association, we are also lobbying for reprieve in that regard.
Thank you so much. So from that, it sounds like as far as structure is concerned, Zim is a little ahead of Kenya. But I want to pose this question to Kimani, therefore. You told us about structures in Kenya. In what ways would you consider that the current REIT structures limit the growth of the REITs market in Kenya?
I think quite a number of responses to that. And for me, the fact that, and there are various aspects to it, maybe starting with the corporate structure. An incorporated common law trust, I feel like is a structure that is not very well understood, even in law school. You'd listen to various debates about what a trust is. In practice as well, the confusion between even in Kenya whether we have, there's a particular act called the Trustees Perpetual Succession Act, which in fact does not convert a trust into a corporate trust, but converts in fact trustees to corporate trustees. So there is a lot of confusion around the law of trust in Kenya, and I know there's a lot of development currently happening to harmonize a lot of the laws around trusts generally, for it to be well understood first by the practitioners, and of course, and if it's not very well understood by the practitioners, then even the investing public, it becomes then difficult to understand it. But how can the REIT structure, in my view, benefit? And I know Justus is here from CMA. We've been working with regulators in market development, especially around legislative development around the capital markets in the last few years. And when you look at a structure that is almost parallel or with similarity with the REIT structure, for me is the capital markets, the collective investment scheme, and I had indicated earlier that a REIT is a collective investment scheme. But when you look at the 2023 collective investment scheme regulations, they do allow, and following the change from the 2001 now to 2023, it permitted quite a number of structures. It permitted limited liability partnerships as a structure that a collective investment scheme can take. It allowed companies and also allowed unit trust, now what REITs currently, the form that REITs currently take. So for me, it's one, starting home, supplanting the lessons learned from the collective investment scheme and being able to replicate that on the REIT structure. But I've heard from my colleague Shava that we even have a concept of an incorporated trust in Zimbabwe. I would want to understand how it works, but it looks like it's something that we can borrow as well. But also now looking globally in terms of other structures that are very, very innovative. Starting from Australia, I know Mr. Mutaura is here, pioneers of the REITs regulations. We borrowed a lot from Australia in the structuring of our REITs, the unit structure, the unit trust model. But we've seen them move again to company structure, including even hybrid structure, that what we call a stapled structure. You have a REIT as a unit trust, and then a company underneath that, a REIT probably investing in income generating asset, and then a company that is owned again by the unit holders who own units in the REIT. That entity investing in property development and management. And what that happens is it's stapled. The security is combined, that if you trade a unit at the top, the unit at the operating level also is traded. So a stapled security, a lesson we can learn, but a bit convoluted, but can work. There's also the company structures in the US and in the UK, and again, a lot of the Europe REIT structure, structured as companies, the US structured as a company, South Africa, we have REIT structured as companies, and looking at those models and seeing, one, with the growth of the REIT especially, in the US market, catapulted to a large extent by companies, we can benefit from such kind of structures.
Okay,
And the conversations are ripe right now.
So the direction seems to be going towards a corporate structure for REITs rather than the unincorporated structure that we have. And perhaps that would then speak to then who manages. Is it the board of the corporate entity, so that there's proximity between promoter, especially the promoter. The promoter should be able, I think, to continue, looking after their investment policy statement and the vision they had at the beginning, which is not guaranteed in a REIT, in a trust structure. But I want to hear in terms of your own views about priorities, starting with Cairo, then Christabel, then Kimani. In your own opinion, when we talk about unlocking Africa REIT markets, what is the single most important reform priority today? Is it tax clarity? Is it listing rules clarity? Is it structuring flexibility? Or is it investor education? All those have been mentioned as critical things before. Which of those would you, Cairo, starting with you, then Christabel, consider most urgent and why?
No, thank you, Peter. I like the party to say that all of them are priorities. So if I was to choose, I would say that over and above the investor education, the most important, at least for Kenyan market, is one, harmonization of the laws. And this is really creating a problem today. A harmonization of the administration between what is CMA doing and what does CMA think about this, what does KRA doing and what does KRA think about this. We need one common ground. Then the next thing we need is consistency. So we need to get to a level whereby the changes need to stop. And everybody has to be certain that I have invested under this kind of structure and this will continue, at least for the foreseeable future, unless something is going to make me change it. We are a little bit in a fluidish scenario in Kenya.
Yes.
So I can come here as CMA and tell you, do all these things, and I'm going to give you your rating. And I go to KRA, and they've got a whole different set of things. Yes, I would say that'd be my take.
Yeah. Yesterday with one of the regulators, and the key word that we got out of there with is checklist. Are you saying that the checklist is not the same between the different people?
Well, I like the checklist because the checklist does give you consistency and lets you know exactly what you need to do. But I go above a checklist. I go above what the law says. And I come up and say, the consistency on administration. Sorry, I'll just take 2 minutes of your time and tell you where I come this way. Yesterday, there was something we were doing, and one of my people gets a call from KRA, and KRA says, we're not going to give you this. And they come to me and say, KRA says, we're not going to give you this. So I call KRA, I'm like, what do you mean you're not going to give us this? He says, no, this is how we are going to do it. And I tell them, no, you just can't sit somewhere and decide this is how you're going to do it. And I said, no. I'm like, no, this has been discussed many times before. And so far as a REIT is concerned, I do not have income tax REIT regulations. You follow CMA's regulations. And they tell me, no, but we are not CMA. And I said, no, hold on, tomorrow is April 1st, not today. I said, no, if you want to resolve it, why don't you just call your friend, my boss, and then we will... No, something like that can totally scare off investors, if you get my point. And the question I had was, if you are telling me this for a new REIT, if I agree, what will you do for the existing ones?
Correct, yeah. Thank you. Christabel, in your view, what's priority, what's most urgent?
In my view, I would think tax clarity and a level of flexibility where REIT taxation is concerned. Why I say that is I believe the nature of a REIT is that its hallmark or its sole value proposition is the pass-through nature of tax. It all hinges on how REITs are taxed. This is what differentiates it from other capital market vehicles, and it's what differentiates it from other collective investment schemes. So clarity on tax treatment is, for me, the best seller. In Zimbabwe, I mentioned that we are currently debating treatment of taxes such as capital gains, reprieve on stamp duty, VAT treatment. This, as at investor level, is what informs my investment looking forward. An investor needs to have a reasonable amount of clarity going in, and it needs to make sense where returns after tax are concerned. And closely related to that is the consolidation of REIT regulation and policies across the value chain. I'll give you a very funny example, but this is actually something that happened on a $25 million transaction. So the biggest REIT in Zimbabwe is the Tigere Property Fund. And it recently acquired a property which is registered on leasehold tenure. So this transaction was a problem from the start. How do you value the lease? How do you convince investors that it's a viable instrument on a 30-year lease? And ultimately, how do you calculate the return? So the tax people came in, valuers came in, and the people sitting across that table forgot one critical thing: the practical end of things. So when you look at it, REIT regulation in Zimbabwe stems from the Collective Investment Schemes Act, the Finance Act, the Income Tax Act. But we forget that returns in REITs are underpinned by property. So where's the Deeds Registries Act? Where's the Deeds Registrar in all of these conversations? So once you get a transaction approved at the ZSE level or SEXIM level, who's the person that's actually going to register the instrument you're speaking of? In this case, we started off by registering a notarial lease, and the notarial lease was sitting with a private company, which then ceded this lease into the REIT. So the question that arose was, does the REIT pay VAT or stamp duties in this transaction? The taxman thankfully said, no, there's no VAT payable in this case. We then engaged the registrar of deeds, who was hearing about this for the first time. So now you have to start by explaining, this is what a REIT is. When we incorporated in 2022, these are the reprieves that we got. But still the question there was, on cession of this lease, practically what instrument do we register? We finally agreed on an endorsement on the primary lease, and one funny question remained. Which stamp was the Registrar of Deeds going to use to endorse that? It had never been done. It's funny, but it held up the transaction for a further 2 months while they tried to figure out practically what this instrument was. So we need to look at it holistically and be able to come up with frameworks that speak to each and every office along the value chain.
Thank you very much, Christabel. Kimani, in your view, what is priority?
I think it's striking, in my view, a balance amongst or between those competing issues. As Christabel has said, tax is really at the heart. Tax is at the heart of REITs. REITs in most jurisdictions are in fact a tax code classification, so that the market then understands that with certainty, of course, with certainty, the regulations harmonize around the taxation statutes, is that then tax is seen, or rather tax benefits and tax efficiency is seen not as a temporary, and maybe to speak to the government people in the room, not as a temporary waiver, like for instance, we had the waiver for stamp duty up to December 2022. And from the view of the public is that these are benefits that are given today and could be taken away tomorrow. So if there is consensus among the regulators, the government, and the investing public that in fact REITs and the tax benefits around REIT is a perpetual benefit, is not dependent on the philosophical perspectives and ideology of the government of the day, then for me, that brings clarity and comfort to an investor bringing their assets to the REITs market. But also, again, you could have a tax efficient structure, but a legally unworkable structure. So it's also understanding, growing with the market, understanding that, again, either we are not at an nascent stage and therefore a REIT market has grown, and we have flexibility around the structure that fits the various investment profiles and strategies of various promoters. And I'll give an example of a recent case and an instruction, or rather advisory request I got from a client, is that they wanted to establish a REIT established under limited partnership under the Partnerships Act, so that for them as a promoter to maintain control of these of the REIT is that they sit in as a general partner, and then the investor come in as limited partner. And the idea for this particular structuring was so such that as a promoter and as a general partner of a limited partnership, I bear the legal responsibility, and for the REIT investor as limited partner, then they only bear responsibility to the extent of the units they hold and they have paid for. So for me, it's regulations that adapt quickly to the various needs, so that a promoter like that then does not start either looking at establishing these structures elsewhere or under any other vehicle, so that then the REIT and the growth of the REIT market is attacked at various angles. So for me, again, regulatory reforms around structure are key, but also allow me to mention the issue of the listing rules, which then touch into the nitty-gritties. And listing rules generally around the REIT structure, because even the capital markets, public offers, and listing regulations also apply to the REITs with the necessary modification, and to the extent that they are not in conflict with the REITs regulation. And some of the small eligibility issues, disclosure issues, continuing obligation issues, again, also need to constantly adapt to the market. For instance, the question that was here with the American Tower about eligibility of infrastructure, tower infrastructure. Does the tower infrastructure, for instance, qualify from an eligibility perspective as a real estate? And I know I've had debates with CMA regarding the eligibility of that. And in my view, and as a firm, Boya Wangongo and Oyaki advocates, we believe the REITs regulation do not, in fact, restrict any use of the asset, for so long as that asset is constructed on land. So whether it's a data center, whether it's a telecommunication tower, so that then, because at the end of the day, at the base of it, at the most fundamental level, they are supported by a lease, which is a real estate. So yeah.
Okay, thank you for that. I know I had Herbert say it's a matter of opinion. That's another opinion, that the law is very clear to Kimani. Now, Mr. Kairu, if your friend keeps their word and we get those tax promises which were made, are there going to be any residual tax concerns as far as REITs are concerned?
Oh, well, my friend always keeps his word. We all know that as Kenyans. That means that, yes, there will be.
Yes.
And the most significant tax concern that is going to remain is actually not the tax, not what's there in the tax statutes, but the administration. And that will always be a concern until the day that we can actually get a CMA and KRA to agree as to who is regulating the REITs. And if we agree that the REITs are a CMA-regulated entity, then insofar as I'm concerned with KRA, then my job is compliance and reporting. That'll be the point. Yes.
Okay. And then Kimani?
I believe the challenge has been 2 or 3 challenges. The first challenge has been the taxes on getting the property out. Now, we don't particularly have that problem in life, but we do have it in general. And it just become really, really expensive. That's problem number one. Problem number two has been on asset classification. And what does this asset become afterwards insofar as the insurance company is concerned? So I think what Kimani was just talking about, insofar as regulations is concerned, we still have that issue, and this is to do with all the regulators. We have the CMA regulations. RBA has to come and tell us whatever it is they tell us. IRA also have come and tell us that if I am holding REIT units, what exactly are they, and so on and so forth. So yes, we do have the tax problem on the property out. That's a CGT we're talking about, and to a lower extent, the what do you call it? The stamp duty. The VAT has been a problem to some extent, particularly should you charge the VAT when the property moves to the REIT, and will you recover that VAT? And then we do have that whole thing of the capital allocation in the insurance companies and the classification of what asset it is, which all of them can be resolved by the regulators sitting together and the tax reforms you're talking about.
Yes, correct. Kimani?
Yeah, I think it's what Cairo has said around classification. And I think this problem was first, I think, encountered at the time of the development of the first REIT, when there had to be some bit of regulatory adjustment to make REITs an eligible asset class under the pension, on the pension side, because when we began, it was not clear, is it real estate? You know, and therefore, if a huge portion of the pension funds had already been fixed and invested in real estate, then we do not have then space for that particular asset class, and therefore there had to be some bit of regulatory clarity around it. And I think it's the same with insurance. I think also with the movement, you know, on the calculation of solvency, what is admitted. No, before we had admitted assets, or rather an asset-based solvency. Now moving to a risk-based, you know, what counts for those charges. So it's again, for me, a question of asset classification more than anything else. Yeah.
Thank you. Any other from the audience? Thank you. Yes, Justice, you want to ask us a question? It's from the regulator. So
I'll be speaking on my individual capacity this time.
Okay.
But anyway, so I just wanted to make a couple of comments, specifically on the interaction between KRA and CMA, and specifically on the REIT space. KRA has been very supportive in terms of engaging them to determine what are the issues that require redress to cut on bureaucracy and ensure that ultimately we have a working market. And I think REK can bear witness. We had an engagement some time back to look at, so do we have to have KRA review certain documentation before progressing the same for ultimate approval. So that issue was discussed. I think there are some amendments we made. So that is ongoing work.
Okay.
The second point I wanted to mention is on some of the comments that have been made by the panelists around which are the priority areas. For us, is looking at, so what is it that we want? If, for example, we talk about consistency. If we developed a straitjacket that is a yardstick for everyone, stakeholders are the ones who are going to come back to complain and say, we don't meet A, B, C, D, E, and therefore CMA needs to be flexible enough to look at these issues from the perspective of growing the market. So that has also to be brought into the picture. So then, even as we engage and remain consistent, remember all stakeholders are not on the same page in terms of where they are in terms of coming to market. So as a regulator, you are left with the dilemma of, do we allow these issues to go ahead, or do we stop it until they meet all the requirements? So it's a challenge that we are continuously struggling with. The third point is around the submissions that will need to be made to ensure then certain points are progressed from here on. And I think some mentions have been made around structure and all that, but I think if we had it all in writing and a clarity on what exactly do you want, and do you have a justification for this? Because again, once you make those submissions, Treasury wants to listen to, so why do you want us to do this?
Okay.
And if the explanations are not convincing to them, then of course they will not progress this. So my appeal is, let's be very clear on what we want. Let's put it on paper. Let's have a structured engagement to it, and I think we'll succeed if that happens.
Thank you.
It was not a question.
Yeah, and that is very welcome. We are happy to know the regulator is on top of these things. I think what we've had is there's definitely need for clarity and certainty as far as tax is concerned. There's need for certain exemptions. There's need for relooking at the structure. And once again, thinking about the promoter who steps out and decides to be a promoter of a REIT, what is their future beyond the listing as a fund, as a REIT manager takes over, and what is their fate? Could they be removed, for example? So all those things then, and I think we've seen also from what Kimani told us, other markets have corporatized the REIT. And from everything you've learned from NAREIT is that it's upon corporatization that, in fact, the REIT market took off. One of the things which has not yet been mentioned, and I want this to go to Christabel, is the fact that Kenyan REITs are only allowed to invest in Kenyan properties. Whether or not that is an issue for reform, we can discuss that. However, I do not believe that there's any law against cross-listing REITs across the region, like any other securities. So to Christabel, what do we need to do for Tigere REIT to cross-list in Nairobi?
I will hammer on tax clarity. What are the implications for a Tigere property fund listing here? Do we enter into agreements that bypass double taxation considerations? In double listing, does a Tigere property fund become exempt from certain listing requirements to avoid duplication of function? Will the Kenyan Stock Exchange liaise with the ZSC to somewhat harmonize certain requirements and accept a Tigere property fund as a functional fund that may not necessarily need to jump through certain hoops that they had to undertake in 2022? Those are some of the considerations that I would top of head think of. What is the actual advantage? Does it make sense to double list? Are we outright doing away with double taxation? What happens in cases where funds need to cross borders? What are the repatriation requirements for funds? Where is the property currently sitting, and what are the implications for an investor sitting in China, investing on the Kenyan Stock Exchange, but also wanting to look at property in Zimbabwe? Is there an automatic system that allows you to have sight of both? In Zimbabwe, we've got 2 applications. You simply go on your phone and there's the ZSC Direct or the VFX Direct app. This allows you to look at counters in real time. It allows you to invest directly without having to go through brokers. So going forward, as we try to leverage ease of doing business, what would that look like if we are looking at a dual listing? So those would be my questions.
Thank you very much. Now we are well out of time. We want to close. I want to give each panelist 1 minute, absolutely maximum 1 minute, to do a parting shot. Cairo.
Thank you. I think my parting shot is that insofar as Kenya is concerned, and Kenyan REITs are concerned, it's been a very interesting journey. And the last 1 year or 2 years, there's been tremendous progress insofar as the REIT environment is concerned, investor knowledge is concerned, with the regulators, with the revenue authority, with the government. And what we can see now is, if we move from that, is even if you look at the assets that people are talking about, really specialized assets, power stations, hospitals, schools, etc., it shows you that the REIT is going to work. We still have a few twitching problems here and there. The structure, yes, can be better. The tax environment can be better. But we actually do have a structure today that is working. And what we're actually doing now as a country, I believe all of us, is to improve on it. So I guess that would be my parting shot.
Thank you. Kimani?
No, I think in this room we have promoters, fund managers, or REIT managers, trustees, critical players and stakeholders in the REIT ecosystem. And from my view, not as a lawyer, but as an investing public, is that there is a huge push and desire from the young, starting from the Gen Z, the young generation, to quite a broad spectrum of age, to invest in a security or an investment that has a return. And in my view, just looking at the market, is that there is a huge shift from your traditional saving, for a rainy day, to now people looking at the bottom line of every investment, people scouting for deals in the market and a return. So for me, is that there's a really, really huge opportunity, and also so people having moved away from the traditional, going to get a plot somewhere in Kamulu, to being able to invest in a stake in a mall, having a wide range of products in real estate that they can invest. So there are many, many opportunities, and the people in the room have the power in their hands to ensure that they grab that opportunity.
Thank you. Thank you. Thank you. Christabel?
In conclusion, this is directed at Jeff. He mentioned that our legislation or policy in Zimbabwe was largely modeled on the Kenyan framework, and that is true. But we have, to a certain extent, made it better, so watch out. We look forward to hosting you so that we have a continuous open door policy where we can discuss exactly how we've also made some of those things better. So that speaks to this recurrent theme of harmonization across jurisdictions. Because what I was speaking to in terms of cross-border listings, in terms of dual recognition of REITs across jurisdiction, is a very interesting concept, and it speaks to creation of scale, which we absolutely need in the African market if we're going to compete against giants such as the United States. We need that. So it's time we move away from operating as silos and look into how we can improve ourselves as a continent and not just on a country basis. Thank you.
Thank you. Thank you so much. Please join me in thanking my panelists, Cairo Thuo, Kimani Njane, and Christabel Shava. Thank you very much.
Thank you very much.